session resumes. In order to create a bit more time for argument, we've agreed that today we won't have 2 tea breaks. We'll have one short 5-minute comfort break, and thereafter we'll have a 10-minute tea break. I know that's going to put pressure on everybody, but it's a sacrifice we have to make for the public good. Mr. Semenya.
Chair, Commissioners, thank you. I thought to start by dealing with the analysis on our terms of what was the nature of the group on the copy on the 16th. Chair, you would realize that there are sharp differences that SABC has with some of the parties, with SABC contending that it was really a distinct large group of people who were on the copy and a similarly distinct smaller group of armed strikers on the copy. And the significance of that difference in our submission is we do realize when a measure such as the unfurling of the barbed wire started, that that type of public order policing technique achieved what is a predictable response from the normal public order situations. 2,000-3,000 of those dispersed without incident, without anything, and yet remained the other 300-400 who were armed and who we say no normal public order policing techniques were capable of diffusing or dispersing them. And we do know as a matter of record that even as late perhaps as it was that the tear gas and stun grenade and water cannons were used on them, the result is what we still had. With that said, Chair, can I invite us to deal with an allied topic, which is what exactly was the nature of the threat that was faced by the police on the 16th. And I invite us to look at page 101 of our written submissions. That is on page 41. Paragraph 101 on page 41. We say that, Chair, that there is an argument that the threat to the police at scene 1 was posed by the front group of strikers who came around the kraal, and that some of those strikers who came around the kraal but were at the back of the group did not pose any threat to the police. And we make the submission that this argument is wrong, and it is wrong for the following reasons. The evidence overwhelmingly shows that the members of the group that moved around the kraal were acting in concert and with common purpose. Even those who may not have had weapons on them, if there were any, because we are still contending that if there were any, they were moving with a group of heavily armed people and reconciled themselves with that reality. Shall you remember that the evidence leaders referred us to Mr. Lidingwane? Referred us, I think, to Mr. Nsonyani, who Mr. Ntsinyelo. Yes, Chair. They referred us to Mr. Litsinyeho in various frames from even the previous days to identify this is the same person with a yellow backpack, and show us that individual again even on the 16th, and argued that he did not have any weapons with him. But if you look at the frame of the 16th, he is barely an arm's length away from the man who's shooting at the police. So you'd have to ask the question, can he innocently say that there is even practical ways of discriminating him against the one who's shooting at the police? And the argument we make there is that he clearly is in concert or has associated himself sufficiently with the conduct of the many. There are verbal threats which are uttered by Mr. Noki and others, and they are talking the we. We are going to show the world how we are going to kill each other today. It must, with respect, be with reference to the we as a group, canvassing all of them. On the 13th, the evidence of the railway line shows a group moving in unison on the command of its leaders, and those at scene 1 were possibly members of the group of 13 August 2012 as well. We make the point that there is evidence that those who went around the kraal followed an instruction from Noki not to run away, and that was the evidence that we had, that he commanded all of those people that he was with shortly before they approached the kraal. And we make the submission that the suggestion or argument that the threat, for instance, posed by individuals who fired at the police could have been handled using a sniper suffers from the same flaw. It's not an individual that was a threat to the police line. It was the armed group as a whole acting in concert with a common purpose under the leadership and direction of Mr. Noki. And Chair, we may need to emphasize what we stated yesterday in a respectful submission, that you are not dealing with a situation of some 3-4 individuals who are in confrontation with 3-4 police officers in an ordinary course of events in this country. You're really talking about a cohort of 700 odd police officers who were in clear display on the 16th, and who the group of 300 or 400 decided to defy. Happily, if we understand the submissions by the evidence leaders, there is agreement that whatever happened on the 16th of August 2012 was not premeditated executions. And we say, over and above the elements which the evidence leaders identify in support of that conclusion, it would have been quite a feat to persuade the commanders at 1430 to commit a crime of that magnitude at 1530.
Understand Mr. Mpufu to contend for that. Remember in his argument, when he and I had a discussion as to what happened, probably happened, understanding was he conceded that the TRT people were probably forming a human block, as it was described. And the intention was that they would disperse and disarm and arrest. But that what then happened was when the tear gas and water cannon was used, at a later stage than perhaps was appropriate, that had the effect. You remember, it was the argument of the evidence leaders as well, that that broke the advancing group into 3. One group being on the side of the kraal, the other one being the head group, Noki was, and then the third group were the ones who turned around and ran. But in effect, this is as I understand the concession, in effect the front group was sort of pushed forward by the tear gas and the water cannon and rubber bullets and rubber balls that it was. And that created the impression in the minds of the TRT that they were being attacked, and that's why they fired. Of course, they argue that in the circumstances, the principles of putative defense don't apply because the rules don't apply. But I understood the concession to be that the intention wasn't to mow them down, deliberately to mow them down, that it resulted from this particular combination of circumstances. If I've stated incorrectly, I'll be corrected. Now, Advocate Himrod points out that what was, I think, conceded was that the TRT were there as a human block to prevent the strikers from going into Nkeneng. There was fears that certain things might happen if they went into Nkeneng. But the point was, I think it was quite clear from the concession that it wasn't the contention that this was a deliberate massacre, that the idea was to mow them down. It was a result of a particular confluence of circumstances which were described. So I don't know that it's necessary for you to elaborate on the point. It seems to me to be correct to say, but nobody at this stage of the inquiry suggests that. If I'm wrong, I'll be corrected, but I don't think I'm wrong.
Yes, that was the only submission we're making, that the evidence leaders also make the point that whatever we can say about what happened on the 16th could not have been a function of a premeditated decision to execute the people as has happened. And I recall you, Chair, you even pointed to the fact that in the middle of international media being present there, it could not, that conclusion could not.
There's a further point that's linked to that I had intended raising earlier, but I didn't. Probably appropriate to raise it now. Mr. Mpofu, in his argument, begins by a quotation from the best-selling work by the French economist Professor Thomas Piketty, and he quotes it on the first page of his heads, making the point, of course, that what happened at Marikana went all over the world and was reviewed with shock and revulsion and so forth. But although Professor Piketty doesn't state it in direct terms, there is an impression created, certainly I think in the eyes of the casual reader, that what happened in South Africa at Marikana was that strikers were killed because they were striking. And Professor Piketty, in fact, refers to two earlier incidents, one in Chicago, both in the 19th century, one in Chicago and the other in France, where the impression seems to be, I'm not aware of the details of those two incidents, that this is a bit like Peterloo, I suppose, earlier in English history, where effectively people were shot because they were striking. Now, and certainly we have read in the media that certain people internationally have made that accusation against South Africa, that how dare South Africa criticize other countries when they themselves shoot strikers because they're striking. Now, I think am I correct in thinking that it's not contended by anybody that the strikers in this case were killed because they were striking?
It must be common cause at least before this hearing, Chair.
If there is a contrary impression out there, either in South Africa or in the rest of the world, that's something which should be
dispelled.
Chairperson, I'm sorry. Just in fairness to Mr. Semenya, I don't want him to argue on the basis of these concessions and understandings, which I'm going to contest. Firstly, if there's an impression that they were shot because they're striking, it's not out there, it's in here, and I'm going to deal with it when I argue.
You're going to contend they were shot because they were striking?
Yes. Today we're ending the strike. That's what Mbombo said.
I see, all right. If that's your contention, then obviously it's one that we have to address. Your contention, you're going to advance it and we'll have to think about it. If you're correct, we'll uphold the contention, and if you're not, we won't.
Yes. Chair, can I then address another point? The case SABS is making in relation to what may in part explain the events of the 16th is that the plan was interrupted. And we know when we look at what is called the Scots plan that indeed the plan was that the barbed wire was going to be unrolled or rolled out. There was going to be an announcement made to the strikers. They were going to be given an opportunity to disperse, and that did not happen for what we now know to be the evidence that the strikers went to the unfurling barbed wire. We need hardly make that point any higher. It's evident even from the video clips that depict the events of that day. Somewhat a little contentious is the role and function of the NMF, extraordinary session of the NMF. Two elements to it. The one is, even if it were to be contended that the decision to disarm the strikers the following day was made by the NMF, we would submit that that would be perfectly lawful, that the highest top brass of the South African police meet and look at the gravity of the situation unfolding in Marikana with 10 lives down and say, no, this has to stop. What we may debate later, as we definitely will, would be the question of was that done with the care required of police service in the circumstances. But there is another difficult subject around the NMF, and that relates to the fact that the National Commissioner as well as the Provincial Commissioner do not mention that event until even Roots appears not to be alive to the meeting that was held there, and the evidence by both the NETCOM and the PC on that issue is that it was an inadvertent omission. But I think, Chair, we can make, in mitigation of that error, if it is found to be one, the very fact that there doesn't seem to be anything ominous about what was discussed there. So the
I know you say that, but why won't they tell us what happened? Why do we get these evasive responses to the questionnaire that I sent out? Why does the National Commissioner herself, when I ask her about it, say that she can't remember? I mean, things have gone dramatically wrong the next day. I would have imagined that the discussion that took place is something that she would have remembered. And she gives me the answer when I ask her, was the risk discussed? She says, I can't be expected to remember pedantic detail of that kind. Now, these are the factors which lead one to, quite facially obviously, it's obviously what you're going to say, to infer that something is being concealed from us. And it must be something awkward, because you don't conceal things that aren't awkward. So if it was, as you say it was, nothing wrong with what was said, perfectly in order, it's understandable, why didn't they tell us all that? Why do they go to these extravagant lengths to conceal what happened from us? Normally, when the witness does something, conceals something or says something untrue, very often there's a reason. Very often, actually, it points, it's like an arrow pointing in the direction of the truth. Now, in what direction does this concealment point?
Well, Chair, again, matter of conjecture on my part, but it may very well have been thought that an announcement of that fact would show a decision was taken by them as opposed to the Provincial Commissioner. even something innocuous like that. I'm referring to the content of that conversation with the top brass. We can accept that whatever it is that was discussed was also communicated to the jock the following day.
Right. I don't want to make it difficult for you by heckling you, but I've got problems that I must put to you. The decision taken was to endorse her proposal, so therefore it was a proposal she made, not a decision she made. A proposal she made which they endorsed. That's the first point. The second point is, you remember I asked her, I said to her, your experience is not in operational matters, your experience is in financial administration. She said yes. I said there were experienced operational people around the table among your fellow provincial commissioners. And if any of them, if there'd been an argument to say, no, but the risks, we must look at it very carefully. Perhaps we mustn't accept your proposal in the form you presented it. What would your attitude have been? And she said, oh no, she would have obviously have accepted that because she accepted her limitations in that field, in that area. And then the further point is what the jock was told, as far as we know, the jockon was told, was simply that she had decided. That was what was recorded in the occurrence book. And in fact, Major General Annandale made it his business to see that was recorded, stood over Brigadier Pretorius while she wrote it. So I'm not sure with respect that, I must put the problems to you, because I may be overlooking them, but I'm not sure with respect that the conjecture you put up is actually going to work.
Chair, I was attempting obviously to answer the difficult question, but also put in the postulate that whatever may have been discussed there couldn't be something inconsistent with what the PC then tells the rest of the world at 9:30 the following day. It can't be incongruent to that. And what the PC tells the rest of the world at 9:30 that morning is something lawful. We are going to wait until there is a voluntary disarmament on their part, but if there isn't, we're going to have to act. Let me attempt, Chair, again to tackle another point. You'd recall, Chair and Commissioners, that there was a whole illustration made during the evidence, which the evidence leaders were suggesting there were two areas on which, around the crawl, the advancing strikers could have been blocked. Path A and Path B. The difficulty we have with that proposition is we are not told if they were blocked, then what? What was going to happen next? Does that mean the police would then retreat back to the jock and say to the PC, we feared that we were going to be under attack? And in the light of that, we decided to come back to the jock and to re-strategize. And if we take that conjecture forward, the armed strikers got into the settlement and killed people, and would have the police service that says to the rest of South Africa, or the only reason we retreated there is because we feared we were going to be attacked. It can't work like that in a constitutional democracy. The only people who have, as we submit, the right under the Constitution to maintain law and order, it's them. And it is not available for them, as it might very well be for you and I, Chair, to retreat and run away and tell everybody else, and perhaps even with aplomb that we may get, for running away. This is their constitutional mandate. They have a duty to maintain law and order. You just don't block it at A or B and do nothing about it. In fact, I think a better proposition, if that were a possible avenue, would have been for Brigadier Khalid to say, mission abandoned. Then everybody else gets into their cars and the people move. Why block them at all?
understand the only alternative, once they'd blocked them, was to go back to the jock and abandon the mission. But would there be anything they could have done? Once they blocked them so they can't come forward, they then presumably the police would have stayed there. They could then have used the tear gas, the non-lethal method, the force continuum, the water cannon. You remember at the demonstration, you saw how powerful the water cannon is. It knocks you backwards. They could have used the water cannon, they could have used the tear gas, they could have used the stun grenades, they could have used the rubber balls. The indications are that the non-lethal methods actually did have the effect of driving that section of the advancing strikers that were not in the front, backwards. So if they blocked them, they then used the water cannon and so forth, the non-lethal methods, in a manner which didn't drive some of the strikers forward and create the impression that they were trying to attack the police, but drive them all back, then presumably they would have gone back towards the copy, and then the plan could have been resumed. But I mean, these are what Mr. Berger calls counterfactual, aren't they?
Let's test that, Chair. You block them at path B, that is at the mouth of the crawl. Where do you use the non-lethal methods? Because you are behind there. The only path, Nyala 4 has already closed that side of the crawl. You close with Nyala 6, the other mouth of the crawl. They are on the other side. How do you disperse people like that? All they have to do is to stand another distance away from you. Then you'll have to open.
But what would they have done? You remember the plan didn't prevent the strikers from going into Inkeneng, provided they took the long road as opposed to the short road. If they'd gone west and entered Inkeneng from the other side, that wasn't the problem. And in fact, if some of the earlier people who left had gone into Inkeneng, they weren't prevented from taking their weapons. That was something that I remember General Allendale conceded in his evidence. So if you stop them going directly into Inkeneng opposite the kraal, you then effectively putting the clock back a bit, and they're either going to stay where they are or go back to the Kopi, because they remember the information was they didn't want to give up possession of the Kopi, and they would fight to retain it, and so on. Or they're going to go the long way and go into Inkeneng. But the plan was, you remember, that once they are in a fenced-off area, then it will be possible for the warning to be given, which presumably will be the Section 9.2 warning, which Brigadier Collins was going to give, and then the rest of the plan could have been resumed. How successful it would have been, of course, is another matter, but it was always going to be that plan, so the police can't be heard to say, well, it's unfair to suggest we should have carried on with our plan if they were going to wanted to carry on with it anyway. The lack of wisdom of the plan kicks in at an earlier point, so we don't have to discuss it now.
But then it means where you had blocked them, you would have to unblock that to go to them, to the copy.
Envisaged, you remember, that there was going to be a block on the other side of the kraal, and there was some suggestion that there would have been some kind of gap through which the police were going to enter. That was always inherent in the plan.
No, Chair. You remember when Nyala 6 was originally positioned in that way? The plan was that they were going to move out as the police from the western side of the kraal. It's only when Nyala 4 and Nyala 6 were brought in that they were going to now use the eastern side of the kraal. And that is where it is suggested a block must happen. Now I'm saying if you have blocked both of them and they went back and you intended to continue the operation, you would have to unblock that so that you go out of it.
Doesn't it depend on the nature of the block? If it was a wire block, because from a Nyala 6,
yes,
then there was some suggestion you could create space. If it was a human block of TRT people in a line, then you haven't got a problem at all, eh?
Well, perhaps this illustrates my point, Chair, with the exchange that we have had. this is a decision that had to be made by colleagues together with all the commanders there in a fractions of seconds, and look at the which of those options would have been feasible and which one would have been practical to implement, and what efficacies would be with one or opposed to the other.
I'm sorry, I don't quite understand that. If the situation we're positive at the moment is there was a human block created, the problem was the non-lethal force created a situation where some of the strikers in the front were pushed forward with consequences that we know. But if that hadn't happened, the human block had been caught and they couldn't advance, then wouldn't there have been effectively a standstill?
Well, there was
wouldn't Carlitz and company could have then had a meeting, decided what to do. They might well have decided to call off the operation until the next morning. That's another possibility which arises. But there were various things they could have thought about. But they were experienced, Carlitz was experienced PRP man. Some of the others were as well, Marafi and others. So the Marafi wasn't there, actually, wasn't he? He was ill. But some of the others were also experienced. One would hope that it would not have been beyond their ability to come up with something that would have worked. It would have been relatively risk-free.
There are two things, Chair. Chair, perhaps two things. There was indeed a TRT basic line human block there. Didn't work. It produced the results that it did. But
why didn't it work? If the non-lethal force had been used slightly earlier, before the strikers had got to that point, then presumably the ones at the front would have done what the ones slightly further back would have done, turned around and gone back. The problem was this concatenation of circumstances brought about by the fact that the non-lethal force was only used after some of the strikers had passed the point at which the non-lethal force was going to be used. Isn't that right?
That's a different point. I was answering or attempting to answer the first one, whether a human block could have blocked them out. And I'm saying that on the evidence, it looks like even the TRT line wouldn't do it. I don't see how a POP line similarly lined on the mouth of the crawl could have stopped them advancing. Around a different subject, the question of the Scots plane. Of course, Chair, if we are correct that there was an attack on the police line of the nature we describe, even on Colonel Vermaak's description of the events that they were impy-like, that no pop techniques could have contained that threat, then there clearly is nothing wrong with what is called the Scots plan, because it sought to cater for that which goes beyond Standing Order 262. And we take solace when we read the submissions of the evidence leaders. They too think somehow 262 should be able to be amended to accommodate something more. It's implicit in their recommendations if you read them, no?
Chair, we say there's a lack of clarity as to whether it applies, and it should be amended to make it clear that it applies in these circumstances. We don't say that it doesn't apply. We leave that open.
Yes, but that gray area says, let's clarify it to make sure that it is patently clear it caters for things beyond.
There was an opacity, I think is the right word, in 262, which should be removed. 262 should spell out clearly what is to happen in this kind of situation. And we will make recommendations in that regard. And hopefully we'll get assistance. Well, we have already got some assistance from you in your heads. Maybe you if you get other ideas which will help to make it clearer, they would be greatly received.
Well, Chair, within as we make the submission, the legislative instruction that is in 92D, the statute there contemplates the use of weapons and firearms if events cannot be contained otherwise.
Supervisor's Sorry, I'm sorry I didn't have my machine on. It authorizes the use of firepower in the particular circumstance. It doesn't say how. That's a detail which one would expect the standing order to provide.
Indeed, Chair. Another subject was the question that there was relative calm after the killing of Mr. Twala, and any offensive action by the police would only serve to escalate as opposed to de-escalate the conflict. Again, if we are correct, Chair, that the decision taken by the PC on the 15th that offensive action would have to be taken was clearly intended to contain what was perceived to be the real threat. And the real threat in the week of the 9th to 16th was indeed that you have heavily armed people who are responsible at the time the decision was made for the death in part of 10 people. There was enormous damage to property. Police officers had been killed. Security personnel has been killed. How much more can you expect an escalation? Would an escalation be another 10 more deaths by that time? 20 more that were to be contained? Of course, the threat in our submission is precisely the very fact that they are this many, they are this determined, they are this armed, and they pose a threat to law and order. That's what had to be contained, we would submit. Another argument is offered that, of course, there could have been a way of putting a filtering line. Now, our submission in relation to that, Chair, is that if we do justice to the evidence and we recognize the terrain, and we accept the evidence that virtually the people who came to the copy came from all directions, really. And you have limited resources as the police do. Where do you put this filtering line? Is it on the western side? Is it on the eastern side? Is it on the southern side? Is it on the northern side? And clearly, if they can see there is a filtering line there, they will go the other direction. And that filtering line, its efficacy is compromised or undermined or cancelled, for that matter. That would be our submission in relation to that. Again, Chair, let us look at another matter. Says General Mpembe and says General Mbombo, in their communication with Lonmin officials, there will be bloodshed. And the arguments, if we understand them, is that must mean that both of them did foresee the bloodshed of strikers. But again, Chair, the evidence by both of them is we have used those words to try and impress on Lonmin people to appreciate the urgency of the dialogue. What could be wrong with that? What could be wrong with that as an explanation to say, please, let's avoid any bloodshed. Please go and speak to the people in the copy. Please, dialogue is the best way of resolving that. Now we dislocate those expressions in those communications and heighten them to the level of suggesting that there was a foreseeability of some bloodshed occurring for the following day. If this discussion of bloodshed and reference to bloodshed was said among the police persons themselves to the exclusion of others, it would bear contextually a different meaning altogether.
I think, if I may say so, that you're not taking into account the purpose of your argument, the evidence that General Mpembe gave when he came back, and when I asked him questions about what he'd said on the Wednesday night, and I understood his evidence to be that he wasn't telling an untruth to Zakwana. What he was saying, I'm considering what he said to Zakwana. He said to Zakwana, "There's no way you can disarm someone on the Kopi. He's got an axe and you've got a rifle. There'd be bloodshed." He then proposed another approach, which one can call the Mpembe plan, which was to get information. And we know that a process was already underway of a team of detectives had come from Gauteng, and they were going through all the footage and seeking to identify the people with the aid of Lonman, so who had weapons, and find out their names and where they were and so forth. And he asked Mr. Zakwana to get the Num people anonymously to provide information also as to who had weapons in the hostels, who had weapons in the informal settlement, so that the weapons could be got there. Because these were daytime strikers, or daytime arms bearers. They used to go home, come in the morning, go home in the evening. Some of them even went home for lunch. So that was the Mpembe plan. The Mpembe plan was, if it had been implemented, been given a chance. Of course, it couldn't be because the order came to, you've got to act on Thursday. If the Mpembe plan had been followed, substantially less risky, it would have dealt with the matter, or may well have done, in a much less disastrous fashion. I don't know that General Mpembe's got the credit that he deserves for A, the sensible approach he adopted on the 13th, and what was clearly his approach on the Wednesday evening. So it's not just appropriate to have regard to what he said to Lonman. You've also got to have regard to his clear thinking on the matter as expressed to Mr. Zakwana.
Chair, even there, it is an attempt to say it's important we go to the copy and talk to the people. So
I'm not in any way challenging what you say there. You've made the submission very strongly that Lonman bears some of the blame for what happened because they were obdurate, and we were asked what is the source of their obligation to talk to the strikers. Well, the answer given was a request from the police, who were doing their best to deal with a very difficult, I think everybody who commented on the matter accepts it was a very difficult situation. Mr. White was quite candid about that. Very difficult situation the police had. They needed all the help they could get from Lonman. They asked Lonman, and Lonman, for reasons which attempted to be made to explain, didn't cooperate. That's the point you're making. That prima facie is a sound submission.
That's right. Also, an attempt on my part to say we place those bloodshed utterances in the context in which they obtained. The other aspect we have to address, because of the submissions made by Mr. Ntsebeza, relates to the scarifications. Chair, if one looks at the post-mortem reports, this is what stands out. Those that were done by pathologists Morat and Ngude do not distinguish between scarification marks that are old and new, but they do make reference to them. And the others are described as fresh scarifications. Now, of those who were at Sinuan, it is only Mr. Lidingwani and Mr. Gwelani, two only, who did not have scarifications.
They weren't anywhere near the front line. So they weren't part of the front group, who you say were the Makarapas.
I will still invite you, Chair, to say that please accept.
You're moving in the wrong direction. That point's not put as a point against you, the point in your favour.
No, I accept.
They weren't part of the front group. They weren't part of the group who you say were the Makarapas. they were people who were unfortunately shot at from a distance when they weren't part of any advancing group. So it doesn't help. You wouldn't expect them to have scarification marks because they were in a different position. Your point is all the front group people who were killed had scarification marks. That's your submission.
That's the submission we're making, Chair. Even where there is argument directed at saying there was channeling at the crawl, nobody can advance an argument with cogency that suggests that channeling was per plan or per design or per instruction of anybody. What I think we see, or what spawns that type of argument, is once you freeze the images at a particular point, you are then able to see them positioned in a way that, to use the language that has been said around that, which has the effect of channeling them. But nobody is advancing an argument that says there was a design or a decision or anything that the people should be channeled. And that must be so, Chair, because to channel them, it means you would have appreciated that the only way in which they could have an escape or an exit would be through one direction. We've just been having the exchange, Chair, that said a whole number of people dispersed westwards. Even after the shooting, the whole number of people did disperse westwards. So it cannot be channeling. And if I understand what the public order policing techniques do, channeling as a method is, and the exhibits are there to show us, it's an effective tool in urban settings, because then you are able to use solid structures to channel people in a particular direction, not in an open field where they can go anywhere they choose. The evidence leaders have obtained now the opinion of Dr. Naidu in relation to the death of Mr. Mati. And Chair, yes, we know that Dr. Naidu did not perform the post-mortem. He came to the conclusion different to the pathologists that performed that post-mortem. He came to that conclusion based on looking at the post-mortem report and the photographs. And the Chair correctly directs that a proper resolution of that conflict of expert opinion, if the second one is also one, is that there must be this conference and a response by the pathologist who did the post-mortem report to say whether or not he still stands by it, and if he needs to advance further reasons why his conclusion is a correct one, can then give it to the evidence leaders. But we cannot at this moment move from a premise that says Mr. Mati was killed by a bullet wound. That conclusion cannot stand. And absent an agreement by the experts, unfortunately, the Commission would have to say there's no agreement on that point. It can do better than the evidence that is available for it. So the argument goes in respect of another element that Captain Lust did not fire on the 16th, and so did the others not. And if you understood the argument, it is intended to convey this conclusion that there could therefore not have been a threat to life. But Chair, you would recall even in examination of Captain Loost, I pertinently put it to him that if nobody in that line had fired at the advancing group, what would you have done? And he said he would have fired too. So it is understandable why he felt sufficiently covered by those who were discharging their firearms at the time.
Wasn't there also some suggestion that in this kind of operation, the commanders shouldn't fire?
Indeed, Chair. But obviously, it is in instances where the commander orders the firing. Well, the facts are a little different, but yes, that is the case, Chair. It is significant, Chair, to draw your Commission's attention to this piece of evidence that when one looks at the people who were lying on the ground at scene 1, you do also see Mr. Magidiwane at the point where he is. He still has his arms with him. So it cannot be that even however belated the non-lethal measures that were taken could not get him just to drop those arms and move on and say, well, this is it. He is still having them at that point. And we need to address what may again seem which may conduce to a misinterpretation in our submission of Colonel Vermaak's evidence in relation to the events of the 13th. He says from the chopper he could see no reason why the tear gas was discharged because as his observation went, it could not have been that the people were going to the settlement. But a careful scrutiny of the record will show that the settlement which Colonel Vermaak was referring to is the one the other side of the river. And that is not what General Mpembe was attempting to do, because he wanted, that is now General Mpembe, wanted to have the Nyalas come into the road that separated the veld from the settlement, the entire settlement. And that vindicates another point, Chair, because there is a debate as to whether or not at that time the strikers were going to the copy or they were going to the settlement. Now we say, look at the body of Warrant Officer Lepaku. That body is almost adjacent to the road separating the veld and house number CO5, which is on the other side of that road. So to say that they were not close to the settlements, to the informal settlement, cannot be correct if you reference that with the point where Warrant Officer Lepaku was killed, and the other striker as well. Very late in the day, we were given a report by the Bapo Bamokhale of some 3 academics who wrote on the question of Muti, Chair. We would like that to be admitted as an exhibit as well. We have attempted to give everyone the CVs that were not initially attached to the report.
By Dr. Mufamadi and 2 others.
That is correct, Chair.
And we were given yesterday, I think it was the day before, CVs of Dr. Mufamadi and her colleagues.
Indeed, Chair. And would say whatever.
Mpofu, I understand, didn't object to the document. He just said he wasn't going to read it. And he said it wasn't of any value, so there's obviously no difficulty about admitting it. And we will have to read it because we have to read everything. We're not in the fortunate position that Mr. Mpofu can read selectively. But anyway, it's in, and I'm sure Ms. Pillay, who's nodding her head, we won't waste time with it now. She will give it an exhibit number, and that will be communicated to everybody.
Chair, the Human Rights Commission has objections to that document. I'm not sure if you'd like me to put them on the record or include them in our note, since they go to the question of weight.
I think you better include them in your note, because...
Chair, we'll also have something to say about that in our notes.
Yes, I understand. There are 2 points. One is admissibility, admission, I suppose, and the other is weight. I can understand there may well be arguments about weight, but I don't know that in a commission of this kind we should be too strict on the admissibility side.
Yeah, just while we're at this, we also object to the document.
You've got that on record.
Obviously, we can only object on the admission, not the weight, since we've vowed not to read it.
Okay, when you exercise your hard-won rights to reply, you can deal with the matter.
Well, yes, Chair. I don't know whether that is going to be quadruple Z something.
Ms. Pillay will let you know when we take the first comfort break.
Thank you, Chair. Can I try and tackle another aspect, Chair? Or at least to finish this exhibit and say, of course it is going to be a question of what weight is to be placed on it. But as we pointed out earlier, it is quite a fresh explanation coming from my reading of the CVs, well-qualified individuals who can speak on that. They may not be able to persuade you, Chair, that they may not be able to persuade you that X is a believable witness, and that's not where we seek their support. Where we seek their support is to say to us that we can accept that there are people in this country who practice traditional, who have belief in traditional medicine. They use it for a whole number of things, and in the main, it is for non-violent purposes. But there are instances when it is used precisely to fortify oneself in relation to whatever is perceived to be a threat to them, and to get themselves strong. Now, you'd recall even at this hearing, at the very least, there is an attempt to explain the use of the muti on a plinth that says it was used for defensive purposes. And we are not told exactly what defensive curtain it offers one who has underwent that muti in the face of an attack. But it could clearly not have been intended to be an attack, a defense against a police attack. And Mr. Mpofu then invites us to say, if they truly believed that the muti would render them invisible, then it is not rational when we see that they realize that the police see them, and therefore it can never offer itself as a rational explanation. Well, there is an answer to that, Chair, and it is this. Often there is no congruence between faith and reason. This country has a fair population of Christians who believe that Jesus Christ walked on water, that he was born of a Virgin Mary, that he took 6 pieces of fish to feed a whole body of people, multitudes of people, that he turned water into wine, and a whole host of other things. Are they rational? I don't want to go down that road, but I'm merely trying to illustrate that it is a belief system. It is shared by many. We respect it. And equally, where the Constitution says there must be the right to belief is protected under the Constitution, it must include the belief of those who think Muti does what they say it can do. We may not like it, and
let me just interrupt you to say that, actually, speaking for myself as a black person in South Africa, I agree with Mr. Mpofu that some of the blacks do believe in Muti use for various reasons. So, speaking for myself, you can bring in the professors from UK or from wherever. It's not going to change that. And the fact of the matter, you can believe in what you believe in, like the Christians and so on. And maybe Mr. Mpofu is right in saying it's not even necessary to read these things, because that's what it is inherent within certain black populations.
And to the extent that it may be common cause amongst some of us, it then begins in a respectful submission to explain what may otherwise be inexplicable. And I'm making this submission purely to remove the temptation that we should look at a rational basis for the use of Muti. Chair, at the beginning of our written submissions, we refer you, Chair, to the sage words in our submission of the Deputy President in relation to this whole conspectus of issues. And we quote the evidence where he says, the tragedy that has occurred at Marikana, page 1.
Page 1 of your reply.
On the written submissions, Chair.
Mainly, thank you.
There the Deputy President says to us, the tragedy that has occurred at Marikana has to be approached as a collective failure by many role players, many stakeholders. And I don't think, he says, that many who had some role to play can say that they do not bear any form of responsibility. I think the responsibility has to be collective, and as a nation, we should dip our heads and accept that we did fail the people of Marikana, particularly the families and the workers and those who died. We did fail them, end of quote, at that point. The significance of all of this, Chair, is there is, in our respectful submission, merit to that. The tragedy that is Marikana was produced by a confluence of factors, as we said. And if it is to be avoided, we as a nation would have to act differently and bring all our shoulders to the wheel to get a different result. And we say in those written submission from paragraph 3, Chair, that the place to start is to accept a common understanding of what constitutes acceptable public order discourse for South Africans. It must also be plain to understand what impedes the achievement of peaceful protest. It must be accepted by all that what we want is a South Africa that is able to offer those who want to exercise their constitutional right of assembly to do so, and to do so within the constraints that are placed on the exercise of that right by the Constitution and the law. We also make the submission that there must also be a common understanding of what militates against the attainment of peaceful protests and assemblies. We must agree that the South Africa we do not want is one where public dissent, be of a social, economic, political, or labor nature, is expressed by groups of persons bearing weapons and bent on conflict and mayhem. We must agree that we do not deserve a South Africa that looks with complicit acquiescence at public display of criminal conduct, where industrial disputes which can be resolved through negotiation and dialogue are left to fester until police intervention is inevitable, where capital can, for commercial reasons, ignore its legal obligations designed to ameliorate the working, social, and living conditions of its employees, and hope to subdue disaffection of its workforce through police intervention. It must be a country where those who hold political oversight do take accountability, I think it should read, for some of the protests which are sponsored by political grievances, where civil society does not express outrage when law and order is disregarded, and where the police are forced to go above the public order tools of law enforcement with resulting deaths and injuries to persons, where trade unions can with ease abdicate leadership and the responsibility flowing from the wrongful conduct of their members. We also make the submission at paragraph 5 that capital plays an important role in the economy of the country, and that with that accepted, the right of capital to participate in the economy must also answer to its duty to resolve industrial grievances through negotiation principally, and that the role of capital in such a democratic discourse is one which appreciates its responsibilities imposed by law, in this case being mining. The responsibility of capital is also to conduct its business within the prescripts of the Constitution and the relevant legislation. More importantly, and directly we say about Lonmin, it was obliged to comply with its legal obligations set out in the Mining Charter and its social labor plan, which obligations were intended to ameliorate the living conditions and working condition of its own employees, which are also intended to restore the dignity of workers eroded by past practices of overcrowded single-sex hostels. And it could do this as capital, appreciating its leverage in negotiations, must always prefer dialogue as a tool for resolving industrial conflict. That share we submit is the South Africa that we submit we should all be striving for. And it is achievable only in a respectful submission if, as we say, all shoulders come to the wheel. But most importantly, before we make our final submissions, it's important that we explain the
Would this be a convenient stage for us to take the first? It's really a comfort break. It would only be 5 minutes. So
Indeed,
so
Chair.
would it be convenient for you I don't want to interrupt the flow of your argument, but
Indeed, Chair.
please, everyone's trying to be back here within 5 minutes.